What if someone dies with no will in Oklahoma? When someone in Oklahoma dies with no will, state laws are in charge of distributing their belongings. This process is known as intestate succession. It can be complex and confusing, and understanding the different steps that occur can help you make informed decisions about your own estate planning or that of a loved one. This article will explain more about the process and important things to keep in mind. An overview of intestate succession laws in Oklahoma. If someone dies with no will in Oklahoma, the state has set instructions on how to divide the person's assets. This is based on your family structure at the time of your death. For instance, your spouse may receive all or most of your assets. However, if you have children, siblings, or some other types of close relatives, this process can change and no longer be as simple. For those with a will, the will dictates who items go to instead of the state making decisions for them. The distribution of assets when there is no will is as follows. When someone in Oklahoma dies with no will, the following scheme applies: spouse and children. In the case of a surviving spouse and children, the estate is spread among them. The spouse gets 1/3 if there are multiple children, or half if there is only one child. The children equally split the remainder. Spouse and no direct descendants. If there are no children but the deceased has a surviving spouse, the spouse inherits everything unless there are surviving parents or siblings. In the case of no spouse or children, if there is no spouse or children, the estate goes to the parents. If there are no living parents, items go to siblings and their descendants. Extended family. When immediate family is not available, items are given further out to grandparents, aunts, uncles, and cousins. Sometimes the state gets it all. If no relatives are located, the estate will eventually escheat to the state. This is when it reverts to the state and begins to support those programs as set out by law. After assets are given to beneficiaries, they can do with these items as they wish. This can cause conflicts within families that are preventable through the creation of a will. Probate court and its involvement is as follows. When there is no will involved, the process goes through the probate court. This court will oversee distribution of your estate to make sure that all actions align with state laws. A major part of this process is the appointment of an administrator to manage and settle your estate. This person is responsible for various tasks of the estate, including paying off debts and distributing assets to heirs. Different types of assets might get treated differently. Not every asset is automatically put through probate. Even if someone dies with no will, there are still particular assets with guaranteed beneficiaries. Assets like life insurance policies, bank accounts, and jointly owned property may pass directly to a named beneficiary instead of going through probate. It's important to understand which assets you have that would fall under intestate succession laws and which would not. An example of some common problems is as follows. If someone dies with no will, it can lead to some complications. The complications can lengthen the probate process. Disputes among family members about who gets what items can arise, more so if relationships within the family are already distant. Additionally, courts must rely solely on state laws. During an already difficult time, loved ones can suffer more from extensive legal complications. This can be particularly tough on families with children or other dependents that relied on the person. Personal items may also cause issues. This involves who gets what, when there is no will to give the beneficiaries direction. These items might not have monetary value but can hold great sentimental value for loved ones. While it's hard to think about, a will can prevent complications and make sure your assets go to specific people. A will allows you to specify who you wish to receive your belonging, list the guardians for your children, and other necessary actions. Probate attorneys in Oklahoma can help you. In Oklahoma, dying with no will causes your estate to fall under state laws instead of your wishes. This can lead to additional difficulties, both emotional and legal, for your family. To avoid these issues, consider creating a will that reflects your wishes and provides clear instructions for the handling of your estate. Our Tulsa, Oklahoma probate attorneys practice in most counties throughout Oklahoma. Call today and get a free and confidential consultation with one of the Tulsa probate attorneys at Kania Law Office, 918-743-2233.